Good evening to all. Today we are going to see about the appointments and statutes. Actually, the topic chosen by me is not related to how to appoint and other thing. If we appoint some person, what will happen if he protests against his termination and other thing? That is the point we are going to discuss about today. And like we see Article 19, everybody knows about that. Article 19 says about that is a fundamental right. So everybody has got the freedom of expression, freedom of association, all these things. And we are living and we are seeing nowadays the media played a key role. Even in companies, they are flickering into the media. And also Article 21, protection of life and personal liberty. No person shall be deprived of his life and the personal liberty except according to the procedure established by law. In this juncture, we need to have a employment bond. Actually, the employment contract is coming from the Contract Act 1956. So the employment bond is very much necessary for all categories of employees, not only for the permanent role and other thing. Because many of the companies, the people are engaged nowadays without having the proper appointment order, like trainee, probation, and people are thinking that they need not to appoint a person on casual for issuing the appointment order and other thing. But that is not the that is the law stated that we have to issue the appointment order even for the contract. And the employment bond agreement is a document that defines the labor terms of the contract between the employee and the employer. So the employment bond, it protects both the parties and provides the standard terms which they mutually agree. Here the point I am mentioning, mutually agreeable point to be mentioned, because if an employee is joining in the company, they are not seeing what we are stated in the appointment order. So we have to clearly state everything, and it has to be signed, mutually signed. In the Contract Act is very clear. The two parties mutually agreed and the terms and conditions should be defined very clearly. That is what in the Contract Act. From the Contract Act only, the employment contract is also coming under that. So we have to mutually agreed points to be mentioned in the appointment order. What are all the things which have to be taken into consideration? One is right of the employees. What are all the rights which are available in the company? We have to state those things. And also we have to mention about the what are all the restrictions if they leave the company, and the penalties also to be mentioned. Because some of the companies, after joining the company, they are not very much inclined to the culture and traditions and other things. So what will be the penalties if they abruptly left the company or abandoned from the service? We have to state. Otherwise, we cannot, because some of the key positions, we recruit the person and we are waiting for 3 months or so. After joining, immediately 15 days or something that he has left. So we have to strictly mention about those things. And the relationship between an employer-employee in India can be either express or implied. So this is very well established. Some of the items we are saying that is implied terms and conditions. Some of the things which should be expressed. We are going to see what are all the things to be expressed in the new code also. That is coming up, new code, which has also stated that we have to issue the appointment order. Mr. Anandan has stated in one of the his session about the code on safety, health, and working conditions. He also stated in the code on occupational process also, it stated that Aadhaar number, universal account number, provident fund account number, insurance number, and skill, wage, avenue for achieving higher wages, higher position, nature of duties, and so on. So this has to be stated in future appointment orders that is coming up in the new code on occupational safety, health, and working conditions. And mainly we have to cover what are all the things we are going to see: name and address of an employer and employee, and the job title or nature of work, and whether we are going to appoint him in probation or conferment position, or place of employment. That is very much essential point. We have to mention the place of employment and what is the salary or wage we are going to give, and data commencement of employment. He is supposed to join in this date, like that we have to mention, or else what will be the juncture at that time, and the period of notice, and the restrictive convenience. This is very much important nowadays. Non-solicitation, confidentiality obligation, and so on. So we have to mention those things also. In many of the companies, that is very they are not very much considered about these points. That is in MNCs. I think MNCs are mentioning all, considering these points, and leave entitlement, and the condition in which transfer can take place. Then the transfer will take place under the thing. The Indian court have taken a view that certain terms and conditions of service which are regulated by statute will constitute implied terms of a contract of employment. So some of the items which are implied one also okay in front of the Indian court. So we like payment of wages, bonuses, gratuity payments on termination, and contribution towards the employee provident fund and employee state insurance can be considered as implied terms of contract of employment, and need not to be recorded in writing. As of now, the courts upheld all these things. And when we see the Employee Standing Order Act, also which stated that consider that will cover the workman only. So in that also we are considering the working hours, holidays, leave, termination of employment, how the inquiries are conducted, if any disciplinary action will be taken against an employee. All these things are stated in the Employee Standing Order Act, those who are coming as a workman. So in the industrial certified standing order also, which state about the how the workman will be treated when the time of appointment, when he is placed under the probation, when he is taken in the trainee case. All these things are stated in the Employee Standing Order Act. Some companies will have a model standing order, some companies will have a certified standing order. So they have to follow according to that. And in the long-term settlement, if the people are signing the wage settlement with the unions or with the internal committees, in that committees also they are signing and they are coming to one conclusion with the points which are stated in the agreement. That is in the 18.1 as well as the 12.3 settlements. So that is also upheld by the court, Indian court. And some of the categories of employees also stated in the Employees Standing Order Act. Those who are coming as a permanent employee will be on the fixed term or on the permanent roles. When the time of retirement, how the termination will take place, that has to be mentioned in the permanent employee category. In the case of temporary employee, it is automatically we are mentioning the time of separation, that is within 6 months we have to close his contract, like that we are stating. In the probationers also, the maximum period is 6 months. So we are mentioning that 6 months period in the probationary order. In now the Bathli workers system is not in place. So Bathli, we need not to consider about those things. In the fixed term also, the contract cessation will take place after the period of his service, or in the mid of the course also he will left the company. That time also the contract will get closed as per the Industrial Employment Standing Order Act. If an employer continue to employ temporary or Bathli workers with the object of depriving them the statutory benefit to available to the permanent employee, that is not right as per the Indian court. So the temporary employee cessation will take place automatically, but the benefits to be extended equal to the permanent employee as far as the High Court and the Supreme Court. And the entitlement to the statutory employment rights is they are entitled for notice period or salary in lieu of the notice. Service of notice period is essential, and salary to be given, and additional benefit like bonuses and all to be at par with the statutory thing and all. And coming to the contract labor employment, in the contract labor employment, the manufacturing or non-manufacturing businesses also covered under the specific shops and establishment legislations are there, which stipulates the terms and the conditions of employment and the service of the employees under the Contract Labor Regulation Act. A contractor is not an employee of the principal employer. as no employer-employee relationship exists between them. In India, the judiciary has laid down the various tests to distinguish an independent contractor from an employee. So we should be very careful when we are appointing the contractor in the company, that we must be very careful. That is under the Contract Labor Regulation Act. And one of the most crucial tests is direction and control test. That has to be taken care while we are appointing the contractor and the employee. There is no direct supervision and control among the contract workers. That is stipulated under the Contract Labor Regulation Act. And coming to the part-time worker, the Supreme Court has taken the view that definition of the workman includes the both part-time and full-time employees according to the divisional manager Needia Assurance employee versus Sankaralingam. Though the appointments and the terms will be different from the permanent employee compared to temporary employee, but the benefits to be extended to the equal, that is for the permanent and the temporary employee, as far as the case of divisional manager named the assurance company versus Sankaralingam in the case of Supreme Court in the year 2009. And the conditions for appointing the manager of the company, that is very much available in the Companies Act 2013. There are so many criteria are there, like age is age criteria, and he should not be insolvent, and all these conditions are there. And the director of appointment of directors of the company, there are so many conditions are stipulated in the Companies Act under section 164. And the continuity of employment with respect to training, there is 6 months, we can appoint 6 months, another 6 months we can extend based upon his qualification and other thing, how he is qualifying for the period, training period and all. Probationary is 6 months, and how we are appointing the casual labor. Under transfer of people from one location to another location, and when the time of amalgamation of the company, we have to be very careful during the employment conditions and all, during the continuity of employment to the people, and maintaining permit and visa on the pass. It is permissible for an employer to provide the employment contract that an employment is contingent or on their having the valid employment visa. So we can send the people for higher education or for the employment in overseas, we can do. The government of India has released a detailed requirements as regards to the employment visas. These requirements stipulate a maximum duration for which foreign national can work in India, and as well as the Indian national can work in the abroad. That is detailed in the government of India regulations. And maintaining the necessary qualifications. When we are appointing some person as a electrician in the HT yard, when we are engaging, we should appoint the C license holder. Like that, there are like a boiler operator. There are some of the minimum qualification is stipulated in the respective act, that is Boiler Act. Like that, when we are appointing some people in the specific positions, we should be very careful and thoroughly we have to go as per that respective act, not by the Standing Order Act. So we have to very careful when we are appointing the like boiler operator or the electrician, like that. Their job duties to be clearly identified, and task and responsibilities to be very much defined. Some of the duties will be implied terms of contract of employment, and they need to be expressed and provided. That is very much quoted in the Dattatreya Sankarao Karde, Mrs. Executive Engineer, in the year 1994. So we have to, in the Bombay High Court, it is observed that terms such as obedience, fidelity, and confidentiality are implied terms of employment contract. So we need not to very detailed. We have to detail in the appointment order. And when we are appointing the overseas, when we are sending the people for the overseas employment, there is a separate agreement can be signed while we are sending the people, and we have to detail what are all the benefits available for them when we are sending the people to the overseas. It is very good for us to maintaining the status quo of an employee-employer relationship. And relocation, a clause can be included in an employment agreement, provided that if an employee resigns before the specific period following their relocation, that may be asked to reimburse the relocation amount. When we are sending an employee for some training, or we are relocating an employee for some special assignments like erection of machines or doing some project, we have to mention about those classes in the appointment order. Such a clause is typically provided in the employment agreement of a senior level employee and not for a workman. And a notice given by an employer. Certain labor laws prescribed a minimum notice period in the event of termination. And in the Standing Order Act also, it is very much clear what is the notice period we have to mention in the termination case. And the Industrial Dispute Act also mandate on employer to provide at least a 1 month notice before terminating an employee falling in the workman category. And coming to the anti-bribery and corruption, in India has signed the United Nations Convention Against Corruption. Under that, the Prevention of Corruption Act 1988 is there, and that is some of the MNCs are nowadays signing an agreement with each employee under this clause. And through that, the Prevention of Corruption Amendment Act 2018, Parliament has introduced a significant changes to the Prevention of Corruption Act. By virtue of that amendments, Prevention of Corruption Act now makes a giving on undue advantage to the public servant a punishable offence. Now we are seeing the government employees are captured by during the Deepavali and other seasons. Their offices are raided by the vigilance people. So that and all coming under this act, actually Prevention of Corruption Act. And coming to the intellectual property, in the intellectual property, the trade secret should not be leaked by an employee. That is very much available under the Section 27 of Indian Contract Act. Over the past several years, courts have treated these convenience unfavorably, though the Bombay High Court observed that negative convenience is considered an inequitable, onerous and abrasive term, and therefore that employee seeking better employment opportunity would not be restrained on the basis of that they have confidential information which, if disclosed, may be adversely affect the interest of an employer. So the court is taking the different decision. Though the court is taking different decision on IP Act and under the clause of restrainment of trade, but we have to mention those clauses into the appointment order. In the case of Tapas Kanti Mantal versus Cosma Films Limited also, the court said that no payment is due to the foreign employee in relation to a post-employment restrictive covenant. Actually, after he left the job, we cannot claim under this clause, actually. That is what the court observation. It has also been held that the employer can conclude the non-solicitation clause in its contract of employment. So the employer can state the non-solicitation, that is, the employee should not disclose the trade secret as per the IP Act under the clause of restrainment of trade to the joining employer. So the employer can seek that is, plaintiff can file a case and he can get the damage and the injunction against an employee in the case of solicit business clients or vendors or employees of the employer, subject to the commercial needs, not for restricting on employee to join in some other company. If we restrict on employee under this clause, court observed that will come under the fundamental rights. We are against fundamental rights. That is very clear in the court judgment. So we have to be very clear, and we have to observe that the employees, we have to be take care of what the employee has done, the mistakes and all. Otherwise, the court observation will fall under the fundamental rights. That is what in the court there is many court judgment from the Bombay High Court as well as from some other court also. Coming to the ESIPF, that is very clear, and during the last session, Mr. Anandan has taken about what is for the international worker. The India has signed the social security agreement with many nations. So if we are sending some Indian nations to the whatever the SSA nations, what we have to do, and if the foreign nations are coming to our country, what we should do under the ESA and the PF Act. Mr. Anandan has detailed about these things. I don't want to spend the time on this. So we have to adhere about before the ESA and the PF laws, that is separate. And the execution formalities. When the time of executing the contract, there is no mandate for to execute the bond by way of register under the Registration Act and other thing. There is no mandate under that. But under the section 43 of the Information Technology Act stated that where a company fails to protect the sensitive personal data or doesn't use the reasonable security procedure to protect such a sensitive personal data, and such a negligence result in a wrongful loss or wrongful gain. So we have to be very careful. So while we are executing the things to the employee, we should be utmost careful. And when we are coming to the breach of contract means legal cause of action in which a binding agreement or bargained exchange is not honored by one or more parties to the contract for non-performance or interference with the other party's performance. That is the word we have to take into consideration. When we can say that the contract is breached, when the person is not performing the agreed terms and conditions, that is called the non-performance, and the interference with the other party's performance, that is called the breach of contract. If the party doesn't fulfill his contractual promise or has given information to other party, that will come under this class. Now, when the person is breaching the confidentiality, so what is called the confidentiality? Employee discloses the information that is crucial for its owner, business or invention, or discloses the trade secrets to its rival companies. That is called the breach of confidentiality. Like an example, if A works under the company X as an associate manager, then he chooses the other employment with the Z. Then he discloses the X client data, trade secrets, and try to solicit his employees, thus putting the entire business of X at risk of being ruined. So the another example is, the most classic example is in the case of Coca-Cola case. Actually, one of the employee from the Coca-Cola leaked the secret to Pepsi. Then that administrative assistant has been found guilty of stealing the secrets, including a sample of a new drink being developed from the Coca-Cola. The court sentenced the executive administration assistant for a period of 8 years and other employees for 5 years, along with a fine of $40,000. So that is the breach of confidentiality, importance of breach of confidentiality. And the penalty for breach of confidentiality privacy, section 66 of the Act provides penalty for using cookies without consent. Such a person shall be punished with the imprisonment of 3 years, or with a fine may extend to 5 lakhs rupees, with the or with the both. Under section 72 of IT Act 2000, a criminal penalty of a government officials, that is not applicable for the private employers under section 72. That will come under the case of secure access to any electronic record, book, registers, correspondence, information, document, or other material. Section 72A of the Act provides the criminal penalty where the service provider in the course of performing contract or discloses personal information without the consent of the service provider. Then that will be the violation, and that the penalty may extend to 3 years or with a fine of which may extend to 5 lakhs rupees or with the both. And how we can get the remedy under the class of breach of confidentiality? There are 3 ways we can get the remedy as an employer. One is injunction, and another one is account of profit, another one is damage. We can get the restrainment order from the civil court under section 39, rule 2 and 3 under the criminal procedure code. for getting the interim injunction, and also the defendant can be liable for profit or earnings by him. So we can take the infringement of confidentiality, and damage also can be imposed against that person. And what are all the items which are not comes under the breach of confidentiality? One is consent. If the consent is given by the authorized person, that is not comes under the breach of confidentiality. And also, when the time of court order or in the compliance with the law, when that time the disclosure is essential, so that also will not come under the breach of confidentiality. And the continued treatment, if someone is taking the medical treatment and all, at that time the doctor has to disclose the things to the respective authority. That also not comes under the breach of confidentiality. And the communication to a threat or a threat of violation or restriction which can cause the injury or bodily harm to another person. That also, there are so many exceptions are there under the breach of confidentiality. And this is about what the ex-employees did. The plaintiff can file the case, and he can take the course of case by way of for the case of breach of confidentiality. And when a person is doing the theft of the data, how we can take the remedy under the Act? In the cyber laws, majorly covered by the IT Act and the rules framed under IT section 43, penalty and compensation for damage to computer and computer system, and section 65, tampering with the computer source of documents, section 66, computer related offenses, section 72, penalty for breach of confidentiality and privacy, section 76, classification can be taken recourse to depending upon the nature of the theft. Under section 405 and 408 under the IPC, we can take the course of criminal breach of trust against an employee. That is also possible. Under section 378, we can file a case against that an employee under theft. Then coming to the non-competition class. If an employment agreement restrict an employee to take on employment in a competing organization or business. Say, for example, if an employee left the company, we also settled and we also relieved him. After that, we cannot recourse the things, and we found that that employee has done a mistake or something like that. While when an employee is in an employment, we can find that yes, he is joining with that. Like that time only, we can file a case and all. That is what stated in many of the courts. In the case of Niranjan Shankar Kolkari versus the Century Spinning Mill and Manufacturing Company, very categorically said that legal position of the court differ on restrictions such as a non-compete and non-solicitation depending on when such restrictions are applied. So that restriction can be applied when it is raised and when it is caused. So that is to be taken care. The court held that such covenants would be valid and reasonable if they operate during the time of employment and would not be considered as a restraint of trade under section 27 of the Contract Act. So we cannot take the course after the employee left the company. That is the Supreme Court case in Niranjan Shankar Kolkari and the versus Century Spinning Mills and the Manufacturing Company. And in the case of DMark India Private Limited versus Zagir Khan, in the Supreme Court said that under section 27 of the Contract Act, restrictive covenant extending beyond the time of contract is void and not non-enforceable. So even though we are mentioning non-competition clause under in the appointment order, that cannot be taken course in the court of law. There are a few cases are there, we will see. In the case of moonlighting and what statute states, in the Factories Act, we are all very much aware of that dual employment is not allowed. In the Delhi Shops and Establishment Act, Section 9, no person shall work about the business of establishment or two or more establishments. So that is restriction is there. And the Industrial Employment Standing Order Act also, Class 8 of the Schedule on B Central Rules provides a provision related to exclusive service, stating that workmen shall not at any time work against the interest of the industrial establishment, he is employed. In the code also, there is the days to come, it will be implemented. That also the state that taking upon any additional employment which may adversely affect the interest of the employer, which will be called as a dual employment. In even today also, there is a notification comes from the ministry, that is a minister has replied to the query raised by one MP. He stated that the dual employment is allowed or not, moonlighting is allowed or not. What is the case if it comes? So they are also not acknowledged for that. They are not allowed that one. So what they stated that we have to follow the rules and the regulations which is stated under the respective law. That is what stated on yesterday discussion and the deliberations taken place in the parliament. One case as I read on yesterday. And Supreme Court also, Niranjan Kumar Sangar Kolkari, century, we already seen about these things. In the case of V.D. Deshpande versus Arvind Mills, Bombay High Court held that an agreement to serve the exclusive for a week or day or even for an hour necessarily prevent the person from agreeing the serve. So he should not do another job when the case he is on employment with one employer. In the case of V.D. Deshpande versus Arvind Mills, in the case of Gulpar versus presiding officer, the Punjab and Haryana High Court upheld the termination of a driver who has engaged in double employment upon the review of the pay slip furnished by the defendant company as a evidence. In the case of Delhi High Court, Wipro Limited versus Beckman Coulter International, that also negative convenience tied up with a positive convenience during the subsistence of the contract, be it with employment partnership, commerce agency. So in that would not normally be regarded as a restrainment of trade, business or profession unless the same are unconscionable or wholly one-sided. When we come to non-solicitation clause, non-solicitation says that it indulging in business with or soliciting with the other employees or customers of the employer. In one case, that is in the court of Calcutta High Court, provide clarity with regards to the enforcement of non-solicitation clause. Employer-employee, MB Software Private Limited versus Samir Kumar Shah. It held that act of soliciting committed by a former employees to take such active form that it induces the customer of the former employer to break their contract with the former employer and enter into a contract with the former employee, or prevent other person from entering into the contract with the former employees, cannot be permitted. So we should not poach on employees of the former employees to the another employer. That employer is same. So we should not do this solicitation for the former employee into the new employer, entire employees or individual employees. That will be restricted under the non-solicitation clause. The Calcutta High Court has specifically mentioned about this one. And the non-disclosure and the confidentiality clause that we already seen. And in the case of court has generally ruled in favor of such clauses, stating that such a protection afforded to business would not amount to restrainment of the trade as it was held in the Bombay High Court in the case of EFH Global Service Private versus Suprida Rai, wherein clause prohibiting an employee from disclosing proprietary information or trade secret would not attract the section 27 of the Act. When we are issuing the appointment order, it is come under the employment contract that is originated from the Contract Act. So when we take the course from the section 27 of the contract of for violation under non-disclosure or confidentiality clause, it won't take it positively for the employer, it will be the positive for the employee. So we have to take the another course only, not under the section 27 of Contract Act for non-disclosure and breach of confidentiality clause. And non-poaching agreement and their enforceability. A non-competition clause prohibits a person to join a competition business, where a non-poaching clause prohibits a competing business to hire the employees. Thus, non-poaching agreement is entered into by competing employer to protect their talent pool. Section 3 of the Competition Act 2002 prohibits anti-competitive activities. However, Section 3 of the Competition Act 2002 does not prohibit lateral hiring within the same band of employees by the competing business, but the absolute ban may attract this section. So we should not attract the talent entire from there, and that will come under the category of non-poaching agreements. And sometimes it is allowing under the Competition Act 2002. In the case of Nazim Marikar versus Marshall Sons and Company Limited, the court in this case said that the employee is free to go away after paying unrecovered portion of expense of training. Here, the employee has been sponsored for the training. He has completed his training and he served under the agreement signed between the employer for specific training for his improving talents into the particular area. Say, for example, for robotic training and all, we are giving the training to the employee, and he completed the training, and he also completed the training period. After that, he left the job, and the employer sued against him. In this case, Nazir Marikar versus Marshall Sons and Company India Limited, the court observed that employee is free to go away after paying unrecovered portion of expenses of training. So employee cannot be stopped for joining on employment after completing his training period and stipulated under the agreement. Special agreement has been signed between the employer and the employee. In the case of Subir Coase versus Indian Iron and Steel Company, in this case, the contract constitutes liquidated damages being a genuine pre-estimate of the damages suffered by an employer, and such sum was recoverable without employer being required to prove any actual loss. So here, the employer failed to prove what is the training cost has been imposed against him. He just away filed a case against an employee when he left the company. The court says that we have to expose the damage when we are filing the damage against an employee with the proof and all. Otherwise, the case will be dismissed before the court. That is what in the case of Subir Coase versus Indian Iron and Steel Company. In the case of Sopra India Private Limited versus Agil Senkal, here the employment was stipulating in the case of failure of an employee to serve the employer for stipulated period, the employee would be liable to make the payment of the stipulated sum as a damage cannot be set be a ipso facto unfair and unreasonable. The court observed that ipso facto unfair and unreasonable. There is no provision in law which declares such clauses to be per se null and void. Under section 27, operates in a different field and does not bar the such employment bonds. So here also, the result in this case was that plaintiff has not suffered any loss or any legal injury on account of failure of dividend to honor. So here, the employee has attended some training or something like that. He has attended and he has served minimum period stipulated in the certain agreement. After that, the company has filed a case against the employee. The court said that there is no legal injury when they are seeing the plight. So they are asking 50,000 rupees against an employee, but they said that you cannot claim that one. That is under the case of Sopra India Private Limited versus Agil Senkal. In the Sikpa India Limited versus Sri Manas Pratim, in this case, the employee has attended one training for about 2 lakh rupees. The company has spent, and the employee left after serving 2 years. Then, but actually, he has agreed for some extended period with the employer while the company has sponsored him for the training. But he left before serving that period. The company has asked entire amount, that is 2 lakhs. But the court said that whatever the remaining period he has to serve, you can claim that. Then the compensation of rupees 22,532 was paid by the employee as per the court order. That is one case. That is in the case of Sikpa India Private India Limited versus Sri Manas Pradeep Dev. That is in the year 2011. In the case of Dosinial Brothers Private Limited versus Easwarda Brothers and others, the Madras High Court dealt with a situation where an employee working as a sales engineer in the breach of his undertaking left the service within 14 months against the conservatively agreed 3 years. So the employee has left the employment within 14 months, but his agreed term is 3 years. The court held that employee was entitled to recover the stipulated damages, which is genuine pre-estimate by the parties of damage incurred. That is in the Madras High Court. In the G Telefilms Limited versus Sundial Communication Private Limited, in this case, defendant has copied the idea and the concept of the client worker Grish Kankaya. This is the one copyright. The defendant has copied this one in the G Telefilms, and he has done this trademark with some other company. That is what the plaintiff claimed. The claimed injunction under the 3 grounds. One is breach of confidentiality, another one is infringement of copyrights, and reversing the passing of the plaintiff work. So these are 3 grounds the plaintiff has claimed before the court, and the court said that led to the defendant to obtain an unfair advantage over its competitor. So the court clearly said that this is ungenuine, that is not genuine cause, and this is not a right to discuss in the court against the G Telefilms. So copyright, the copyright under the Copyright Act, he cannot, or infringement of confidentiality cannot be claimed under this case. Actually, in the Bombay High Court, it was further held that the injunction order has been given with the consent that merely compensation, that is what allowed under this case. In the case of Daniel Corus versus Steel Authority of India in the year 2017, there was a drawing took by the Steel Authority of India and used in some other some other company, and they quoted very less. And the Steel Authority India filed a case against an employee. The court held that respondent is liable for breach and had passed on interim relief restraining the respondent and his agent disclosing the confidential information to the third party. They referred the case of Dilichit Titus versus Alfred. This is the case for infringement of copyright and the breach of confidentiality. So a person has stealed the drawings of the Steel Authority of India and used for some other company, and the court observed that this is coming under the infringement of copyright and the breach of confidentiality in the case of Steel Authority of India. And in the case of Neera Mathur versus LIC in the year 1999, Neera Mathur applied for a job and not mentioned her pregnancy and other maternal details in her declaration form, that is in the appointment, that is application. And subsequently, she has been interviewed and she has been selected. And when the time of joining, her name was missed, and she actually protested against in the court. And the court said that you should not question the maternity things and all during the time of declaration in the that is application form. That is the infringement of his privacy. Like that, they stated. They quoted very well, referring the Article 14 of the Constitution of India in the case of Neera Mathur versus LIC in the year 1999. And in the case of Ambiance India Private Limited versus Naveen, the defendant was employed by the Black Tea Company as a fabric technologist, and he has agreed to serve for many years, and also he used the same year, that is before that he was working with Indigo Orient Limited of UK, and that was not disclosed with the Ambiance India Private Limited, and he left the Ambiance India Limited. Subsequent to that, the company found that the person was working with Indigo Orient Limited UK, and the plaintiff said that the defendant has not disclosed but has a trade agreement with them, and he sealed the plaintiff company documents and all, and used for Indigo Orient Limited of UK. But the deviance said that the business of Indigo is different from the Plantic company. So their business trade is trade is different, and Indigo Orient Limited is different. That was the defiant stand before the court. But court accepted the plea of Plaintiff and given interim, though the trade secret is different, under the Special Relief Act under Section 27 of Contract Act. So another thing is background verification. Nowadays, the government is very much putting pressure on getting the details of personal information. We all know that about the RTA Act and all. In the case of K.S. Puttasamy versus Union of India in the year 2017, the Supreme Court observed that this is coming under the right to privacy. But as far as the private employment, we can do the that is get the information under the security practice and the procedure and the sensitive personal data or information rules under in the year 2011, that is coming under the SPDA rules. We can collect the data of financial information, physiological and mental health conditions, sexual orientation, medical records and history, as well as the biometric information. But we have to take care of those information are very secret, and we should not disclose to anyone without the consent of an employee. That is very much essential. We should not leak the information about the on employee. But for the public servant, it is not allowed. That is in the case of K.S. Puttasamy versus Union of India. But we can do for the private employees. As per the act quoted in the security practice and the procedure and the sensitive personal data or information rules. That is Passport Act also. They are stipulating many conditions while we are sending the people. This is what I want to say. This is about my presentation. If any queries.